he is going to join us. He's got a hurricane coming his way, folks. But he says he thinks it's going to miss him. Um, so hopefully he'll be safe, and hopefully everyone will be safe, actually. Can you guys hear me? If you can hear me, wave at me. Ship, can you hear me?
Yes, I can hear you.
Fantastic. All right, I have moved to a different place in the house, you guys. Cable company still has not been here to give us our stuff, but I moved to a different place in the house. Oh, people are waving so they can hear me. Fine, fantastic. I'm hoping that the coverage is going to be a bit better here, and my power is definitely better in this room. So hopefully, we're going to be cooking with gas, as they say. Yes, Taylor, it is sad that the cable company can't manage to get its act together yet. One day they will. Hey, there's King. All right, King, let me make you a co host. Fantastic. Now, see, it shows me that King sent me a request to be a to be a speaker or a co-host, but then the request itself doesn't actually show up. It's strange the way this just sort of doesn't work right. Yes, Bill, I agree. It might be time for Starlink. We've discussed that. If the local folks can't get their act together here sometime relatively soon, then I will be calling Elon for sure. King, can you hear me?
Sounds like you moved into a new house.
We did. But we are making progress, you guys. I have only about 300 of the 450 boxes left to go. So we are getting there. It's a slow process moving after all these years into a new house, but it's coming along. And actually, we took some time off this past weekend. Our wedding anniversary was Sunday, so we took some time off. We went down to the Outer Banks, saw Kitty Hawk. Um, Steve had not seen that before. I had seen it years and years and years ago. We went to Roanoke Island. So we had a really, really nice time. Got in the ocean on Sunday. That was nice. So we are refreshed, rejuvenated, and ready to talk law. So, okay. So what we wanted to talk about tonight was sort of an update as to where where Donald Trump stands in his legal, I mean, saga that he's got going on in multiple jurisdictions, right? So, what shall we start with first? Chip, do we want to start with Judge Chutkin's order in the DC case?
Well, I mean, we can. I'm not sure there's a lot left to discuss there. I mean, the she issued an order
Well,
that
we haven't
essentially
discussed it at all. I know it's
no,
been discussed in general, but we haven't talked about it with our folks at all.
yeah, but I think when we just discussed the hearing that day, we anticipated what the order was going to be, and the order was exactly what we discussed. Um,
Yeah, but I don't feel like we've kind of fully explained to people like all the issues that we see with it. So let's do that.
okay,
Um, Okay, so she says in her order that she's setting certain pretrial deadlines. Um, she and there were actually some significant little data points on here, I thought. So she says she's reopening supplemental briefing on Trump's motion to dismiss based on statutory grounds. Now that's not entirely, but it's largely based on Fisher, right?
correct.
So she claims she's reopening that in the first part of the order. And then we're going to get back to that because she goes on, she sets the following deadlines. So she says government's evidentiary disclosures due September 10th. That was yesterday. I take that to mean like discovery disclosures to the defense, don't you? Like not publicly.
Correct. Just if I think there was a limited amount of additional discovery that the government acknowledged that they needed to produce, but that they had it basically at hand. So
Right.
she gave them a week.
Right. So she,
Yeah, it was yesterday a
right.
week. Yeah, she gave them a week to get that
Yeah.
out.
Yeah. Then the next thing is defendant's reply brief in support of his motion to compel and motion for an order regarding scope of the prosecution team. She said that was due September 19th.
Yeah. Now
So that,
those were all frozen
Yeah, go ahead. Yep.
When the Trump defense appealed the immunity order to the D.C. Circuit, under the rules that froze the entire case. So nothing from that day forward that she had previously scheduled was done. So she is now going back to those items that remained unfinished as of the date. I think it was December 7th or 8th of 2023. As of the date she lost jurisdiction, she is now rescheduling the events that had not yet happened.
So these were two defense motions. One was to compel the government to produce certain things, and the other was this one where they're trying to force her to define who's on the prosecution team and who's not. That makes a difference for the Brady disclosures, because if you're part of the prosecution team, then the government has responsibilities under Brady, and if you're not part of the prosecution team, then they don't. So that was partly briefed because all she's ordering is for the reply briefs. Just so people know, when you file a motion, it's your argument, you file a motion, the other side opposes, and then your final word brief is called a reply in federal court. So that's called a reply most places, I think. So she's not scheduling any of the others, so presumably those are all already on file, and just Trump has the right to file a reply on those. And she ordered those due on the 19th, so next week. So we haven't seen those yet. Then the next thing she says is the government's opening brief on presidential immunity due September 26th, with defendants' response and renewed motion to dismiss based on immunity due October 17th. And then the government's reply and opposition due October 29th. But then she does not say, let me look at it here. She doesn't say in this order, unless I missed it. King, did you look at this? Because we talked about it a little bit offline. She doesn't seem to set a date for Trump to reply on this renewed motion to dismiss based on the immunity. She's not giving him the last word on that, it looks
She
like.
does
Did you
not.
guys notice that?
The government gets the last word under this.
Right. Now I think under the rule he has a right to reply, don't we agree?
Well, curiously, I've gone back, had reason to go back and reread the Supreme Court's opinion a couple of times. The Supreme Court says it is the government's burden
Right.
to rebut the immunity, the application of immunity.
Assertion. Right. Yeah.
So I think that probably, generally speaking, as we all understand, the party that has the burden is entitled to the last word.
Right. Which is at odds with the motion rule, which is if you're putting the motion forward, you have the last word.
Correct.
But because you can put forward a motion on something the other side has the burden on, you still get the last word in terms of the
Right.
motions. But often you do see judges do this, right? Where
And
they
the,
basically
and
say,
these are all
yeah,
just,
but
yeah, these are rules that are all subject to or as otherwise ordered by the court.
yeah, right. So if I were them, government, if I were Trump's lawyers, I don't know if I would be thinking that we don't have the right to file a reply. I mean, she's left it out of this order. You could infer from that she means you don't have the right to it. But under the rule, you have a right to it. So, what do you guys think?
Even if you don't have a right under the rule or the order, you can always ask for it.
Yeah, you just
Yeah, that's
ask for
true.
leave, and in this circumstance, I think she'd be hard pressed to deny it.
Right, I agree. All right, so let's just focus on this immunity then. So go back to the dates. So basically, Judge Chutkin agreed with the government's position that they should be able to lay out all their evidence. They're going to have a paper trial, basically, on September 26th, right? And then Trump has until October 17th, which that's 3 weeks, not a full month, right? Now, normally on motions, it's only 2 weeks, so that's more time than the rule allows. But it's still not even a full 30 days. That's a lot of work to do on that, to respond to that, don't you think?
And I don't
In
think,
3 weeks?
yeah, but I think she she made that ruling completely blind
Mm-hmm. Right.
because just like we spoke about last time, this thing from the special counsel could be 5,000 pages long.
Yeah, exactly. Right. And when you count all the exhibits, it probably will be.
Exactly. There's this is folly, and I wrote and I think that I think they should
Did you
move to
write about this on your
yeah,
Substack?
I think they should move to
On your Substack?
reconsider this
Mhm.
order and go because
Yeah.
if you go back through and read carefully sort of the indications that the Supreme Court gave about how this process should unfold, it's nothing like she's allowing.
Right.
I would move to reconsider, and I would quote the Supreme Court at length. They make repeated references to the challenge should be on an allegation by allegation basis. And the first thing I'd say is the government opted, as the Supreme Court basically directed them to supersede this indictment. Who's to say that the Trump defense wants necessarily to assert immunity in every instance? There
Right.
may be issues that they think, we could get an immunity order there, or we could fight for immunity there, but there's other evidence to rebut that we want.
Right. Or we might waive on certain things because we think it's to our advantage.
Exactly. This
Yeah.
process needs to begin over again with a new motion asserting immunity on a line by line basis.
Based on the new
Yep.
indictment. I agree with you. Right. That should have been the defense should have raised that and then caveated it by saying, and we're also moving vis-a-vis any other evidence that the government plans to use, which we haven't delineated in this motion, and they need to identify that
Right.
of like a placeholder for that. But
And I now I did write, but I'd sent you and King a note, but I wrote about withdraw the motion because that's the position she took. The position she took in the hearing was that what has happened is a motion to dismiss was filed. She issued her order. The order was taken up in the appeals court and was affirmed. It was then taken to the Supreme Court and it was reversed. So in effect, they've sent her. What she said in the hearing was they've sent the case back to me to revise my order. So in effect, the motion to dismiss remains pending. And my first thought was is going through this order like, well, withdraw the motion. Now there's no motion pending.
right,
If there's no motion pending, there's no purpose for this government filing.
for Jack Smith to file this behemoth thing that he's going to file on September 26th. Right.
Now, I think that's
It
still
also doesn't make sense. Her saying that doesn't make sense then with what she has in her order because she's calling the thing that Trump's supposed to file defendant's response and renewed motion. How is it a renewed motion?
well, it shouldn't be a renewed motion. It
Right.
should be a motion to dismiss the superseding indictment, which happens.
Right.
I'm going
Exactly.
to file one on
Right.
Friday. I've got a
Right.
superseding indictment of a case with a new count included that I'm going to move to dismiss. It's just a motion to dismiss a particular count in a superseding indictment. It's
Right.
not a
I
renewed
mean,
motion
she's
of a motion I've already
right of
lost.
your old one.
Mm.
She's saying that the existing motion is still pending.
Well,
How is it a renewed
the
motion?
existing motion, I think, is moot
It's moot,
because because
Yeah.
it addresses the
It's
original
based on the
indictment.
old indictment. Right.
which is no longer in existence, so to speak.
Right. So her whole thing that, well, they sent it back to me to redecide the motion, that this is inconsistent with you in your own order calling it a renewed motion. And also the superseding indictment kind of resets the whole thing anyway. So like none of it makes any sense
I
actually. There's no coherency.
I don't know what they're going to do, but I have to think that the gears are turning in that defense team to try to prevent this. And
Right.
I would file a motion for reconsideration of the schedule. Well, first I would withdraw the motion to dismiss. I would file a motion for reconsideration on the scheduling order, put her to the task,
Yeah.
and then I would appeal. Even though it's an irregular, likely not an interlocutory, I would appeal on the basis it's
Yeah.
a novel question of first impression, and the process that she has put in motion is inconsistent with the language of 5 justices of the Supreme
Is
Court.
inconsistent with what they just decided, actually.
I,
Right. Yeah.
I,
So hold on to that. We're going to
I'd go
come.
further than that.
Yeah, King, I know what you think about that, and we're going to come back to that. So hold on to it. So let's keep going here with the order because there's another point here that will help us with this analysis. So she goes on to say, all right, so Smith's supposed to file on September 26th, then Trump gets to file on October 17th in response, and then the government gets to have the final word on October 29th, which, what is that? A week before the election. Then it says defendants supplement to his motion to dismiss based on statutory grounds. This is the Fisher argument, right? Is due October 3rd. The government's response due October 17th. So she told them at the hearing she wanted to decide all these things at the same time, and then that's not what her order says. Defendant's request for leave, get this, leave to file a motion to dismiss based on the appointments and appropriations clause due October 24th, with the government's opposition due October 31st, defendant's reply due November 7th. That's 2 days after the election. So she is not saying that Trump, in this order, she's not saying Trump has a right to file to dismiss on the grounds that Smith isn't properly appointed, but that he has to seek leave to do so.
Well, but this came up during the hearing, and I I have this impression that we had a spaces after the hearing, but we didn't. Because I was going to the hearing, we did it a couple of days before. This came up in the hearing, and the issue that came up is she inquired as to why that shouldn't just be considered waived, since the date for
Right.
filing motions had expired before she lost jurisdiction.
Jurisdiction. Right. We talked about this several
Right.
times. Would she allow that? Would she not?
And basically the argument didn't go very far, and she finally just she just came down on the side of, well, look, I'm going to go ahead and allow the defense to file this, because everybody recognized that in the DC circuit it's a closed issue, that
Right.
she made a couple of comments about the judge in Florida, judge in another district, based upon dicta in a concurrence, which she was referring to Thomas's opinion. And she sort of asked John Lauro, Trump's lawyer, goes, I hope you have some really special argument that somehow I am able to ignore controlling precedent in the DC circuit to
Right.
follow another district judge in another circuit, or dicta in a Supreme Court opinion. And Lauro he made kind of a half-hearted gesture to the thought they would be able to convince her. And I'm thinking to myself, that's the wrong answer. The right answer is, Your Honor, I recognize that there may be circuit authority that binds you, but as a defense lawyer, we're obligated to make the argument for purposes of a record, and the outcome might be a foregone conclusion, but that's what we would like to do. And he never said that. I think it would have been simpler if he had just said that, because at the end of the exchange, she basically said, well, I'm going to go ahead and allow the defense to file on this issue because everybody recognizes that I am likely obligated by the DC circuit's existing opinion on this question.
Well, and in the hearing, the government lawyer said a couple things sort of on this point. One was the point you just made that, well, the defense they have to file things because they have to preserve things. And he also said he didn't see how the government would be prejudiced by letting the
Correct.
defense raise it
Correct.
now, although he pointed out that there is an argument that it was waived. So, and I read several reports of that hearing, including some of the things you said, Chip, and I came away with it with the same impression that you just said, which is she'd basically decided the defense was was going to be allowed to file that. But then her order, it did sound like she was trying to see if the government wanted to make a waiver argument, and they didn't really bite at that bait. But then her order is very clear that the defense, she thinks, has to request leave to file
Well, but
that.
I think that's only because it's already out of time. In other words, she didn't extend the
Mm-hmm.
time. She's
Mm-hmm.
just basically saying it's out of time. So if you want to file it, seek leave. I don't think she has any intention of denying leave to file.
Aha. Okay, you think she's just being pluperfect. I mean,
Correct.
she doesn't have to do it that
Correct.
way. She could have already decided it and said the court grants leave, and this is what the schedule
Right.
is.
Right.
But that's not what she did. I think she's trying to give the government another bite at the
They
apple
might,
to make the argument
but
that this was waived already.
I think given her comments, she might allow the government to argue that, but I don't think she would
Hmm.
basically block the
It's not
motion
going to rule for them.
because it's
Yeah.
like as we just said, she's only got one answer that she can give, and she can say it's not me, it's them.
Right. I can't change what the circuit said. Right. Okay. But on this question of do they have to have leave and whether there might be a waiver, I wanted to specifically go over that because if we go back to the question of should the defense kind of withdraw or strike its motion to dismiss on the immunity grounds and then try to refile it later, might she not very well take the position that that's definitely waived if you withdraw it and try to file it later?
I don't think she could do that because of the superseding indictment. That triggers a defense
Mhm.
right
Mhm.
to
Mhm.
file an A. I mean, as long as I've been doing this, every time there's a superseding indictment, that issue comes up. I'd like another opportunity under Rule 16 to file, or
Right.
under Rule 12,
Right.
Rule 12 to file motions.
12. 12.
And, the judges
Right.
always, I've never had a judge say no.
Well, why isn't that the same then for Smith's appointment? I mean, that argument obviously applies to both indictments, but so did the immunity argument.
Well, no, the argument for Smith's appointment could have been raised before and wasn't. A motion to
Right.
dismiss was raised before. Now you have a superseding indictment, partially in response to a success on appeal of the motion to dismiss. So now you got a new indictment. It's like, well, I want to dismiss this one too. They didn't fix the problems.
Right. But I thought I just heard you to say that if you get a superseding indictment, often the defense wants to say, well, basically the time gets reset for your Rule 12 motions to dismiss, and you can basically start over, raise arguments that whatever your arguments
I'm
you
not sure
have.
you can re-raise anything because arguments that you could have already raised and didn't,
Hmm.
the
Right.
court can say, your time to file the motion to dismiss based upon the appointment is gone. That was something that you could have raised before, and nothing has changed, and you didn't. Um,
Okay, but that still takes me where I was going, which is okay, they for the first indictment, they moved to dismiss based on the immunity. Now she's basically telling them you need to renew that, refile it again. Um, but if they don't, if they decide not to, or if they withdraw it, like what you're suggesting, before Smith files this gargantuan thing he's going to file, um, I would be concerned that if they then tried to file it later, that she would say, "Well, I gave you an opportunity to do this, and you chose not to, and I'm not going to let you do it now."
Again, though, I would. I mean, it begins with the existence of the scheduling order and the procedure she's adopted, so they have to challenge that first.
Right.
I just
Except
think
they're kind of not because
again,
she's making Smith go first, or she's
right,
letting Smith
right,
go
so
first. Yeah.
I mean, they have to. I mean, my view is it is a well, I want to say it's not one off, but this is all an issue of first impression. So don't just allow a procedure that prejudices you to become the subject of, oh well, I guess we'll do the best we can.
Right. We've acceded to this order, which makes no sense 6 ways for Sunday.
Right.
I agree with you. I would file a motion to reconsider and lay out the problems with this, line it up with what the Supreme said, point out what the issues are. And that goes to your point, King, that you think this order in and of itself is violating Trump's rights, correct?
I do.
Okay, so explain that to folks.
Particularly the order authorizing or ordering Smith, the prosecution, to lay out his entire case. That is, let's add to the indictment. Let's fill out the indictment with underlying facts, and
Right. Paper, it's a paper
let's
trial, is
support
what
those
it is.
underlying
Yeah.
facts with evidence. And Smith has already told us where he's getting that evidence. it's grand jury testimony and documents, and it's FBI 302s, which are the memoranda that the FBI agents write when they interview a witness. And that's all going into the public record. And it's going to be, and its purpose there is to help win an election. But the secondary purpose is for the judge to read it and consider it in making findings of fact on immunity. And I think it is a really strong argument that doing it that way, one,
Without cross
violates Trump's
examination.
Fifth
Yeah.
Amendment rights of due process, and two, Trump's Sixth Amendment of right to confront and cross-examine witnesses against him, because grand jury proceedings are secret, and
Right. There's no
and
defense
there's
lawyer. There's no cross examination.
and
Right.
and there's and no right to cross-examination. And when this gets dumped into the public record, Trump's got no way to make those people come and be cross-examined. And it's too late anyway. His examination rights are lost if he doesn't get to do it right then and there when they testify. Doing it 6 months later or 2 years later is, just from a trial lawyer's perspective, is worthless. You need to eyeball the witness, hear him on direct, and then jump down his throat right then and there. If you can't do that, you've lost the right of cross examination.
And it just raises other problems too, like you're tainting the jury pool. Because in criminal cases, you might litigate certain pieces of evidence pre-trial before the court, right, in public filings, but not basically your entire case. The entire case the government's going to put on. And, most of the time, jurors are never going to read your pretrial filings for your case. But there could be plenty of people in the DC jury pool who might be following this case closely and reading the filings.
Yeah, and
So,
that's the Sixth
there's
Amendment.
just so many problems with it. Right. It
Yeah,
is.
that's
So
the other
it
part of the Sixth Amendment. That's the other part
yeah.
of the Sixth Amendment uh, problem, which is your right to trial by jury. And if you've got a jury that is significantly tainted by reading in the press what Smith's grand jury case was,
Said, right.
wh-
Right. Or they go to the docket
eh,
and read it. Right. Jeez Louise. Well, what did you guys think about this? I was puzzling over how would you fix this problem if you were a judge who really wanted to. One thing that occurred to me is, especially in civil cases, but sometimes in criminal cases, parties do joint filings, right? Smith doesn't have to go first, and then Trump gets a month to respond. She could have given them 90 days or maybe 60 to work together, right? Exchange stuff that they're doing back and forth, and flesh out what all of the issues are that she has to resolve on the immunity question, and at least start this process of whatever we're doing in a more even-handed way,
well, at a
so that they
minimum,
would file something
eh,
together. Yeah.
at a minimum, if this procedure, as Smith suggests, requires him to, oh, uh, uh, lay out all of his cards turned up so the other side could see where he's
Yeah.
coming from, do that
Right.
under seal, in secret, not in the public
Right.
record, not so the judge could see. And that's the beginning of the process you just described, which is parties come together with the issues I need to decide, and then we'll discuss how we get that decided. Do we need live testimony? Do we need legal briefs, or a combination of the two? But at a minimum, none of that should be put in the public record until the
Just
parties
dumped one-sided.
correct.
Yeah.
Well, and here's another reason for that I don't think, and I have to believe there's something coming before that disclosure date.
Oh, you think?
Well, You have you're going to have
Every one of Trump's cases, it's like so many things happen that the lawyers can't even respond to them fast enough.
right.
So I don't doubt that something else will happen between now and September
Okay.
26th.
Well, no, I mean in terms of in this case before they get to put that
Me
document on
too.
the record.
I agree.
What I've got to point out what King just said about the grand jury disclosure of the grand jury material. I mean, Rule 6E gives her the authority to order a pretrial disclosure of the grand jury material preliminary to or in connection with a judicial proceeding. That
Right.
so there's nothing that stops her from simply setting 6E aside for whatever the special counsel
Appropriate
thinks
purpose.
he
Right.
needs to
Yeah.
use for this filing. Um, but within that material is likely attorney client material that is going to have to be relitigated on the crime fraud exception.
Right.
I-
Yes.
you know, so
Right. She'll have to make rulings on
right.
that
So
before it can
how
be
does that
used.
become
Yeah.
public before whether or not it's confidential is litigated? All of that crime fraud crap in the grand jury is litigated behind closed doors, so it doesn't become public.
Right.
Ship, I want to take issue. She has the right under the rules to exclude or to provide for the filing or the publication of grand jury material. But that doesn't address my problem, which is the Fifth and the Sixth Amendment issues. Can that grand jury testimony and be used against Trump in the judge's ultimate findings on facts underlying immunity? That's what she's being asked to do. She's being asked to consider what Smith files to determine factual issues such as did Trump's conduct fall within his official acts or was it strictly private? Those are at a minimum mixed questions of law and fact.
Yeah,
And
but the Supreme Court opinion at least four times talks about this being a fact-intensive inquiry that must begin in the first instance in the lower court. She has to make factual decisions, and this is the only record. The
she she
evidence.
she has to. I agree, but she can't base it on grand jury testimony where Trump has not had the right to cross-examine witnesses.
I don't disagree, and that's why I think this process has to include live witness testimony.
Eventually.
I don't think
Right.
she can make.
I
I don't
agree.
think she can make those determinations without. You're right. Without affording him his Fifth Amendment right to due process and Sixth Amendment right to confront and cross-examine the witnesses, because she cannot establish what the facts are. I mean, it's no different
Yeah.
than a suppression hearing. Sometimes a
Right.
suppression hearing has to be the officer testifying and being cross-examined by the defense.
And exactly.
Right. Sometimes you even put your own client on in a
Right,
suppression hearing. You put the defendant on to say, well, that's not what happened. I didn't give my consent. The cop twisted my arm, whatever.
right.
And yeah.
So
And this
so
goes back. This goes back to the issue that I've raised over and over and over and over and over again, which is that's why you can't do this on the basis of assuming the facts to
On
be
the
true.
Yeah.
You
Right.
have to actually establish not what the facts are, and the only way you get to what the facts are is with a contested evidentiary proceeding with witness testimony under oath.
Right.
it,
So we're really talking about the first step here. So I was thinking, people don't probably know this because most people are not doing this. When you're trying a criminal case in federal court, the judge has to instruct the jury as to what instructions we're following, what law we're following. The way that actually works is that both sides submit to the judge what they think the instructions should be. Okay. But in practical reality, what often happens is the lawyers get together and they exchange their proposed instructions first, and they figure out which ones they agree on and which ones they don't agree on. And then you submit a joint pleading to the court that says, we agree on all of these, here's the ones we don't agree on, here's the language the defense wants, here's the language the government wants, here's our legal positions on why we want this language, we need the court to resolve these problems. It's not like the government presents their instructions and the defense gets to respond to them. The parties craft a paper together where they can see one another's arguments before the judge gets to see any of them, and you present the entire package to the judge. And that to me would be fairer as a starting point in this situation.
Certainly, what is ultimately and like black and white in my view unfair is for the uh, FBI 302s and the grand jury testimony to be filed in the record to be used by the judge to help decide these issues.
Well, and
That,
let me point out why you're exactly right, King, and that's because, as we all know, when you're working outside the courtroom, everybody knows that an FBI 302 is a statement by the FBI agent. It's not a statement by the person being interviewed.
Right, is what the
It's
agent decided to hear
yeah,
and write
it's
down.
what the agent decides to write about what the person said, and the person who said that might disagree.
Yeah, they usually do, in
Right.
my
So
experience.
so to say that I'm going to make factual for a judge to say I'm going to make factual determinations based upon what's in a 302, it's like, "Oh, well, what about if we hear from the person actually? Wouldn't that be better?" You know, let me
Right, because basically what he's proposing to do is use all of the investigative one-sided tools and present that to the court as if those are
as if they
established
are
okay.
facts,
facts.
correct.
I'll go further. What he's proposing to do is to turn this into a star chamber proceeding. You have evidence taken in secret, either by the FBI or the grand jury, and it's going to be the basis of deciding what the facts are that will determine whether Trump has immunity or not. And that that's the kind of thing that medieval England courts may have say is okay, but in our system of
We
justice,
believe in
they
the
do not.
adversarial process
That's
here.
right.
Well, let me let
Yeah,
me let
right.
me give you
No.
a flavor for how disingenuous this exchange was. Now, it's now coming back to me that we had our prior spaces before the hearing that I sat in and
Right, we
listened
did.
to.
Yeah.
This is how disingenuous this exchange became. As
Oh, we lost King. Oh, hopefully he'll come back. There he is. Okay. Keep going,
as
Ship.
the as she was inquiring of both sides, she first asked the government. She said, this is what you're suggesting is procedurally irregular because normally the party that's filing the motion would go first, and what you're in effect saying, Mr. Special Counsel, is that you should file in advance a sort of a pre justification for why the motion to dismiss on immunity grounds should be denied before it's even spelled out. And that seems explain to me why you think it would be correct to turn the process upside down to some degree, and proceed in this irregular fashion. And he had some goofy answer, which is exactly what you would expect it to be. Oh, we just think this is simpler, blah blah blah.
It's more
Right, right.
efficient.
More
It's clearly more
efficient. We
efficient.
can, we can. We're. Oh, I know. His big issue was, well, Your Honor, we're prepared to file now, so we can go faster if we do it this way. Whereas
Right.
if we wait for the
Yeah.
defense to file the first motion to dismiss, we anticipate it's going to, and sort of saying, and we understand why it would take them longer, because they haven't we've got access to all this material. So we just think it promotes efficiency for us to go first, and then they can have as much time as they need. It's like while this, smoking turd of a evidentiary bomb sits out there in the public, 4 weeks, 5 weeks before the election. I think I did. I think I counted. It's 40 days based upon his. He said 3 weeks from the date of the hearing, and then there were been 40 days left from the date they file until the election. And then Lauro gets up there and she asks him the same question. Well, I understanding this is irregular. Why wouldn't this be sort of a more efficient way? Well, he doesn't want to come right out because he knows how she's going to react. He doesn't want to come right out and say because there's a friggin' election, Your Honor. Um,
Right.
because and he does make some comment to that effect, and she's, oh well, I have said before and I'm going to say again that my decisions on how to proceed have the electoral calendar has no impact, and I'm not
Right.
even going to consider it. This I'm just try to manage this case. Um,
And she says that like that's the best answer, which we're going to get to judge what Judge Marchand did in New York. I don't think that is the best
right.
answer. Do you guys?
Well,
Just pretending like the
well, right, yeah,
election's not
yeah.
happening? That's
You're in a
ridiculous.
fantasy world. You're not in reality because there is an election and it is going to impact it. You may say that's not your intent. So what? That's the effect.
Yeah. Right. Exactly.
Um,
Right.
so I'm sure when we dropped the atom bomb on Hiroshima, we really only intended to kill soldiers.
Right.
Um,
Well, maybe not, but right. It's like, okay, but you did.
yeah,
You can't ignore that the real world exists. It's
right.
not just courtroom in the world.
So
Yeah.
now,
Well, I didn't think that Lauro s- adequately articulated King's point, which is that simply letting Smith lay out his evidence first is a violation of the Sixth Amendment. At a minimum, it should be joint, and it should probably also be sealed, at least initially. And really, what needs to happen is the parties need to refine the issues, and then there needs to be a hearing at which the judge takes testimony. That's what should happen, but that's not what's going to happen.
God dang it.
Chip, can you hear?
Oh yeah, I thought I cut myself.
I think you
All right.
did just cut
Yeah,
yourself. Yeah.
I was searching for something while having the spaces open, and I hit the wrong X, but it didn't kill my.
Good.
Um, so well,
So
let
that
me the
is.
one
Go
I've
ahead.
lost my train of thought, but the one thing just to cap off the question how disingenuous this exchange was when Laura was objecting and trying not to say, you're introducing this into the election, he's trying to avoid that being the basis. She comes back around and
Yeah.
says, well, Mr. Lauro, in effect, doesn't this help you? Doesn't it help you for the government to give you all of this information that you then have to work with? You're not working in the blind and trying to craft a motion to dismiss. I it was so pathetically transparent and disingenuous. Yeah,
Yeah. Because on the surface, that's right. I've been saying that from the beginning. The government should have to identify what it wants to use. That's it. So the subject of the immunity argument. That's true. You have to have a starting place, but that doesn't mean you dump the whole thing on the public record with, yeah, and give Trump 3 weeks, to reply to it. That's absurd.
yeah. As I understand your point, but as I read the Supreme Court's opinion, obviously the Supreme Court said that all the DOJ stuff had to come out. That was just clear in the opinion. Said that was the core
Yeah.
constitutional issue. Trump is the president. The executive branch controls investigation and prosecutorial decision making. As a president, he's has every right to tell his Justice Department what he thinks they need to investigate,
Whatever he thinks.
and
Right.
that is not something that can be inquired into. So that had to come out. So the idea that there was going to be a superseding indictment was a given, no way
Right.
around it. But then I think the process, as explained explicitly by the Supreme Court, is it's a allegation by allegation analysis of whether or not it's an official act. If it's an unofficial act,
Right, that's the
right,
analysis. That's the analysis she has to
exactly.
undertake, but that doesn't tell you exactly how do the parties prepare their
Well,
presentation to the
but
judge in order for her
I
to do
understand
that
that, but
analysis.
I think it assumes. I mean, assumes. I mean, it says outright that that begins with the defendant. The defendant. What are you claiming is an official act, Mister Defendant? The government is claiming they're all unofficial acts. Otherwise, they wouldn't be in here.
Right. But it's just running smack into the practical problem that we've talked about the whole time, which is that, but the defense isn't actually in possession of the knowledge of exactly what the government is going to offer as evidence. You can go through the indictment and pick out all the allegations,
Oh,
that's
oh,
fine,
oh.
but that's not the whole field.
No, I understand, but I think that's where it has to start. The government makes a, or the defense makes a motion. The following on a line by line basis. We challenge the following.
Right.
Then then it's up to the government to rebut. Now they come in with their evidence, but they have to disclose that evidence ahead of time. As they would not in a public filing, but just here's what we're going
Right.
to use. Then they attempt to rebut the presumption by saying, and I just published a Substack article yesterday that talks about that is essentially a. I don't think they can. I'm not sure they ever will be able to because the bar the Supreme Court created is so high. The
Right.
test that the government's created is that essentially no danger to intrusion into the authority of the executive and his ability to operate the executive branch. Not a manageable danger, not a balancing of factors, but they they use the phrase no danger.
No danger. Right. Now, I didn't interpret that to mean anything different from what the Nixon formulation was, which is anything within the outer perimeter of the president's powers is off limits.
But then they
It's
but
kind
they
of
made it
those same
but they
things said
but they
differently.
made it rebuttable. They don't. There's no rebuttable presumption in Nixon, which or Fitzgerald versus Nixon. There's no rebuttable
Right.
presumption. It's just off. It's just you can't do it. But they created a rebuttable presumption, presumably because this is a criminal proceeding and a heightened sense of public interest. Blah blah blah. But the test to rebut the presumption is so high. I can't see how the government could ever surmount it. How could the
That's
government
what I'm
ever
saying.
say?
I think that I agree. I think the
Oh, at the
test
end of the
is
day, I think you're
actually
right.
the
Yeah,
same. Yeah.
at the end of the day, the bar is so high they can never clear it. So functionally, it's the same thing.
Right. So, all right. Well, I mean, I didn't think, but King, I'd like your opinion on this. We've been tossing this around, and you were the first among us to I think, accurately articulate what the Sixth Amendment argument is. Lauro claimed there was a Sixth Amendment violation in his pleading, and he sort of talked about it a little bit at the hearing, but I just didn't feel like he actually articulated that well for the judge to consider. Maybe it's just instinctively they knew that was a problem, but they hadn't come up with the right formulation to make it clear.
I've had a case uh, in my career, what going way back, and I remember when it first occurred to me. There's not a lot out there on that.
Right. There's no
There's
law.
there's
Lauro
not
didn't
there
cite a
is
single
some law. There
case.
is some law, but it's hard to find, and it's there's not a lot there. It's something that dropped by the wayside, as I said, in medieval England when Parliament said to the king, "You can't do that in courts anymore," and they made him stop. Uh, and since then, we don't see it in English common law or in U.S. jurisprudence. Period.
It's just a
It's a
given.
given.
Right.
And the case I had involved uh, a high-ranking state official who was being accused of ethics violations, and the state govern, governor-appointed ethics board had met in secret, like a grand jury, received testimony, then came out of their secret session and charged this guy with ethics violation, and then said, "Okay, now show us why you're not guilty." And here's the transcript of all the evidence we compiled against you. And I said,
So disprove
Something's
that. Right.
wrong here." You know, I how does he cross-examine that? You know,
Right.
and it's fundamental. And I lost at the first level, but finally the state Supreme Court said, King, you're right. That is
You're right about
that
that.
is not only a Sixth Amendment violation; it's a Fifth Amendment violation. That's fundamental due process, and
Right.
it's so unusual that we don't see it.
Steve had a case like this recently. He's not in here
Mm.
with me tonight, you guys. He's over in the kitchen making dinner for himself. But um, he had a case recently that he won in federal court because a one of the federal agencies that does, it was like part of commerce where they do incoming goods evaluations and like tariff type stuff, and they had fined this company for importing a certain item, and they said because it wasn't manufactured where they said it was manufactured, blah blah blah. So the company was fighting these fines, and when they fought it with the agency gave them a redacted rationale for why, for the basis of their reasoning, like explaining the mathematics and the numbers of how they used it to determine that the goods were not where they said they were from, but they wouldn't disclose to the person who was being fined the actual data. And Steve was like, "Yeah, you can't do it that way." But the agency did it that way. And then they went to the first line of appeal, which was to a federal court, special court. And the judge was like, "Oh, yeah, that's no problem." And so Steve then appealed it to the federal circuit. And the federal circuit was like, "Are you people all insane? We don't fine people money for misconduct and then you don't tell them the actual facts on which you're fining them." Like that's insanity. They were just like you're saying, King. They were gobsmacked because it seemed like just such a fundamental error that they had a hard time grasping how these lower agencies and courts could have missed this point. But here we are,
It, and
and that's what's happening.
and
This case is they're not seeing the actual issue.
in
Go
in
ahead.
in my brief, I gave the state Supreme Court a history of the Star Chamber courts in medieval England and said that's what's happening here. Do we want to resurrect the Star Chamber courts?
Right. Yeah. Do we think that's a good idea? Negative. Right. So, yeah. But you've got somehow you just get confused. And these folks in this agency were like, well, we don't have the power to do a protective order, so we can't give you this information. Steve and the Court of Appeals were like, the fact that you don't have a protective order doesn't mean you don't have to give the person the information that their violation is based on. Like, what are you talking about? But we just are straying so far from our essential core principles that this is where we find ourselves. It's unbelievable. But it is a subtle issue, don't you think, King? Like, and I think that's why Laurel didn't articulate it well. They did raise it
Yeah,
in their brief. They do say that, but it's not spelled out well, and they don't cite anything except the Sixth Amendment.
it's
So
a it's
go
it's
ahead.
a real subtle issue, and you have to be a
Yep.
trial lawyer to really grasp how fundamental it is. Because, as I said, if a lawyer representing a client is not there when witnesses give testimony and give statements to the FBI, and then is told, well, this is evidence, you know, it you climb the walls
Right.
at that
These are
point.
the established
Yeah,
facts. You weren't there to help establish
yeah,
them, but
you
oh
weren't there to
well.
cross examine, you weren't there to confront, you weren't there to put on your own side.
You know,
And
I've had this issue kind of come up in odd occasions in oral argument where this issue becomes a, something that was in the grand jury or something that's in the indictment. And, and the comment I always make is, don't don't forget, Your Honor, one of the first admonitions you give to trial juries: the allegations of the indictment are not evidence.
Right. Right. Those are not facts. Established
Right.
facts. That's not how it works. Yes. So, all right. Well, it's a problem. The schedule that she set out is seriously problematic on multiple levels, but so far Trump's folks haven't moved to reconsider that. Now maybe they will, because this is the kind of thing where you would you would want to do it as soon as you could, but you also would want to research it carefully. You'd want to actually articulate it well in your brief and make it crystal clear to the trial court, if, and possibly the Court of Appeals, more likely, really, right? Exactly what's really wrong with this.
Well, let
So
me
maybe they will, or maybe they
let me
won't.
chase out just a bit what I had written, which is that assume so let's say so what's the ticking clock on the disclosure date? The 26th?
It's the
Okay,
26th, yeah.
so we're on the 10th, so we got 16 days, or no, we're the 11th. It's 9/11. So we got 15 days left. Let's say you file that motion. You file that motion with a request for the court to stay the filing pending the outcome of the motion.
Right.
Because you want the court to say that the government cannot file on the 26th unless the court authorizes it.
Right.
Because of the pending motion to reconsider. So you ask not only for a motion to reconsider, but you ask for a stay of the scheduling order pending the outcome of the motion to reconsider. If she denies that, if she says, well, I don't think your motion to reconsider is well taken, blah, 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 I'm not going to, then you take that to the circuit and you ask the circuit to issue a stay.
Right, which is very unusual, as we've told folks before. Normally, you just simply cannot appeal scheduling issues,
Right.
But this is not a normal case by far. So, and you're talking about the implication of constitutional rights. They might, and it tied to the immunity. Immunity clearly can be appealed, so they might make an exception for that.
Or you might at least get an administrative stay pending
Yeah.
being able to be heard, which could then put
Right.
off that September 26th date. And then if you don't like the answer you get there, you go to the shadow docket of the Supreme Court. And then the Supreme
Right.
Court gets to say, you are not consistent with the process that we told you need to follow.
You needed to follow. Yeah. I want people to understand this idea of an administrative stay, because we're going to talk about that in the one of the other cases too. So, administrative stay is you're not asking for a stay of the thing you're trying to prevent on the merits. You're asking for a stay of the thing you're trying to prevent while the court considers your arguments for the stay.
Right.
So, you're going to ask for the stay. You file a motion that says you should issue a stay while we're briefing my arguments about why a stay should exist. And that's called an administrative stay because it's not based on the substance of what you're claiming is the grounds for the stay. It's based on we're not prejudicing, we, the courts, are not prejudicing your ability to even ask for the stay by letting the thing go forward while we're considering what you have to say.
The reason why I think this would be an interesting path to follow is if you want to get something that the judge has to pay attention to in terms of process, this is a path that gets you to who? It gets you to Roberts.
Right. Somebody other than Tanya Chutkin, for
but
one.
Roberts has the DC Circuit.
Right.
And we are,
but I mean, you want to get somebody else other than her,
and we are in the
whoever it is.
summertime. The court is out of session, and this will be on what they call the shadow docket. And if there is a chance to get somebody to say, no, 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 that's not what we want you to do. Yes, we told you you have to do it in the first instance because you didn't do it the first time like you should have. That doesn't mean you do it in a fashion that is so obviously tilted towards the ulterior motive that you're trying to accomplish.
Right.
Just like
right, and Roberts might go for that because he was so obviously annoyed at the way he handled it in the first place.
This is another example of trying to go too fast and screwing up the process.
Right. In the meantime. Right. All right. Well, let's move to the next issue, the next case, which is the New York case. So, here's what happened, you guys. I looked at the docket and some of the papers today. this is very interesting and a bit complicated. So the case was set. This is the New York State case with Judge Marchand. This is a criminal case brought by Alvin Bragg. And as we all know, the jury had found the former president guilty of this ridiculous records offense. So Judge Marchand had ordered the sentencing set for September 18th, next week. In the meantime, the defense had filed, in light of the Supreme Court's decision on immunity, a request for the case to be thrown out or a new trial and a bunch of stuff based on the fact that Marchand had let in evidence that the defense is saying was evidence that's subject to the immunity. Okay. So Marchand said in his order earlier this summer that he would decide the immunity issue by September 6th, and that if it was still necessary to have a sentencing on the 18th, that's what would happen, but it could be turned into something else, presumably if he, you know, agreed with the defense about the immunity. And that's where it stood up until recently. And then, as King has advised us so very well in earlier spaces, Trump had tried to remove that case from New York State Court to New York Federal Court, just like folks have tried to remove the Georgia Fannie Willis case from Georgia State Court to the federal court in Atlanta. Trump's lawyers tried to do the same thing in New York, and they were unsuccessful. And we're not going to rehash that ground again, but just for purposes of today, the federal judge said no, they could not remove it. So the case went forward in state court. In light of the Supreme Court ruling, Trump's lawyers tried a second bite at that apple. They tried to get the district court to remove the whole case into federal court. And so they filed that in the district court on September 3rd. So Marchand had not ruled anything yet. Said he was going to rule something by September 6th. So on the 3rd, Trump's lawyers try to remove the case back to federal court again. The same day, the federal judge denies leave to file the second removal. Now, you can file an untimely removal action, but you have to have leave of court to do so. So the Trump people tried to file the removal action, but the district court said, you need leave to do this, and I haven't given you leave. And so he dismissed that case and said he denied leave. That was on the same day that they filed, September 3rd. On the 4th, Trump's folks filed with the district court judge still a request to stay his ruling while they appealed his ruling to the Second Circuit. And then on the 6th, the district court judge denied that request for a stay. Also on the 4th, though, the Trump's lawyers filed an appeal and a motion for a stay in the Court of Appeals. Now, New York is in the Second Circuit, too. Second Circuit. So Trump's lawyers filed this appeal and a motion for a stay in the Second Circuit. They asked for both the administrative stay and for a stay of the district judge's ruling. On the 5th, the government opposed the administrative stay. And on the same day, the 5th, Trump replied, asking again for the administrative stay. On the 6th, one of the appellate court judges referred the request for the stay to the panel, whichever three judges were going to be assigned to it, which they didn't say who that was. And then that is still pending. Nobody has decided anything in the Second Circuit yet. Meanwhile, the government filed their opposition to the motion for the stay on the 9th. So that was 2 days ago. Now, in the meantime, on the 6th, Judge Marchand doesn't decide anything, but he announces that he would postpone deciding the immunity issue until November 12th, and he's reset the sentencing date for November 26th, again, depending upon whether that's needed based on whatever he rules on November 12th. So this case raises some of the same issues we've just been talking about, like questions of administrative stay, and should the judge take into consideration that, by the way, there's an election coming up here in a couple of months, and so forth. So what do you guys want to take up first on this case?
Well,
Let me.
I have not followed those rulings. Um, other than just sort of, at a distance, seeing them being made as they're made without looking at too much of the actual paperwork involved. But I think the issue that struck me was comments that I read that Merchan seems to maybe be coming around to understanding that while the immunity issues exist, he can't go forward. The immunity issues
Right.
have to be resolved before the case can move forward in any fashion. And the Trump motion to set aside the verdict, or however that's formulated, is exactly the kind of issue that the case law consistently says has to be addressed before he can rule on anything else. Now, I, I had thought that he had it set up. I thought that he had it engineered such that he would rule on the immunity question, likely deny it, and then in 48 hours, go to the sentencing to, the supposition was not leaving enough time in between for Trump's lawyers to seek any kind of appellate relief to prevent the sentencing. Um, so I'm not sure. I haven't read if he
Well, he had
offered a
originally said he was
justification.
going to rule. Yeah, he had, in terms of the dates, he had originally said he was going to rule on the 6th, and the sentencing was set for the 17th. I'm sorry, the 18th. So there would have been enough time in there for
No,
them
no,
to
no.
seek
It,
an
it was
emergency.
it, it was the 16th and the 18th. It was only 2 days.
No, it was the 6th. That's why he issued this decision on the 6th. That's why on the 6th he said, now I'm not going to decide this by today. I'm going to decide this in November.
All right.
But did he did he
Go ahead,
did
Chief.
he fix a separate date in advance of sentencing in November for the ruling on immunity? I think he did. How
Yes,
how
he
many
did. Yep.
days?
He
How
said,
many days in advance?
again, 14. So he's going to rule on the immunity issue on November 12th, and the sentencing is set for the 26th. So it's the same thing. It's a 2 week set off.
It's I know that Trump's team, if they lose the immunity decision, they plan to appeal and ask that the sentencing be stayed pending that appeal.
Which that should work, right? For the same reason that it did in front of Judge Chutkan. You have a right to interlocutory appeal on the immunity question.
I'd say probably, but there's a difference here. The difference is that Trump is not claiming that his writing checks, personal checks that were entered in a certain way on the books, were immune. What he claims is that immune, otherwise immune official acts were used as evidence against him to convict him of a crime involving private acts. So it's an evidentiary issue more than a immunity for the conduct. If you follow that
Right.
distinction, so
Yes, I do. That's the point I keep making, is that even in the DC case, it's not just the allegations, it's also what evidence is the government going to use, even if they want to use it for an allegation that might not be immune. But the Supreme Court, I thought, was very clear that you can't use immune evidence either, even if it's in support of an allegation that maybe is not immune.
so
So,
so if for example, Judge Merchant holds that the excluded that the evidence Trump wants to exclude because it was immune conduct, uh, really was immaterial to the jury's verdict. That it despite, even if that evidence had not come in, he'd have been found guilty. What does that do to his appellate rights?
see, the way I read the Supreme Court opinion, I don't think it can be used against Trump in the trial period. So if you used it and you, judge, let it in, you're screwed. You got to start over again. I don't think, Ship, I'm interested in your opinion about this, but reading this, what the Supreme said, I don't think they're going to tolerate harmless error analysis for use of immune evidence. Do you?
It's correct. I do not think. I think if that was Marchand's intended decision, that he was going to deny the motion for new trial, set aside verdict, whatever, however the motion is styled, based on harmless error, that's reversible error. And I think somebody has probably gotten to him to say, that doesn't work because, the basis of immunity is to not face trial. So you can't let, that's like, that's almost like letting, attorney-client confidential information come into a trial, which turns out later to have been wrong, and then by saying, well, but it was harmless
But
because of all the
apart
other
from that,
evidence.
Chip,
It
apart from that,
prejudices the proceeding.
apart from that, I'm talking about the right of interlocutory appeal. If
Yeah.
he holds harmless error in
No,
advance
I
of
agree.
sentencing, does the interlocutory appeal right come into play at that time, or does Trump have to wait until after he's sentenced to
No,
raise
I
the?
agree, and that was the argument that was the first comment I made was that what I had read, the little bits that I had read over the last couple of months, so to speak, or since the Supreme Court's immunity decision, that where there were arguments beginning to be made that this undermines the New York case because of certain evidence that came in, um, that he can deny the motion for new trial based upon the improper admission of evidence subject to immunity, but that is itself appealable. You're right that freezes the case prior to sentencing,
Right. We're
even if
all
he
agreed.
denies it.
Sounds like I think we're all agreed
Yeah,
on that. Basically, we're saying the rule is if if what you're trying to appeal has to do with the application of your immunity right to you, your case, evidence that came into your case at all, I think that's appealable immediately.
yeah. So Merchand's two options, if he is to say either the evidence wasn't subject to immunity, which is appealable, or to say that the evidence was subject to immunity, but its admission was harmless, that is also appealable before sentencing.
Which is why I think his order reads the way it does, where he basically says he sets the second date for the sentencing both times, saying if it's going to be necessary. I think he knows it's going to get appealed.
So,
Right? So there isn't going to be a
so
sentencing.
what is this? How does this affect the removal and the denial of removal and the appeal of that? Because
Right.
ordinarily, if you remove a case and the federal court denies it and sends it back, um,
You can
you
appeal that, but the case
you
keeps
can
going
appeal
in
it,
state court.
but it doesn't
Right.
stay anything, and the statute says that you can't
Right.
get a stay.
Right. Now, interestingly, the government argues in its paper that its opposition to the request for a stay from Trump's lawyers, they're trying to stay the state court case while they appeal the district court's ruling that they can't file a second removal action. Do you follow that? And the government says, well, the stay that Trump's lawyers are asking for is of the state court case, but the district judge ruled that he didn't give them leave to file the removal at all. And so the stay that they're asking for is not a natural consequence of what they're trying to appeal. Do you see what I'm saying? They're saying the remedy they're seeking isn't really legally available based on the point they're trying to appeal. So the district, I'm not making it clear. So the district judge said, I'm not giving you leave to file a second removal. And now Trump is trying to stay Merchand's case while they appeal that. And the government's argument is the district court's ruling that you didn't have leave for a second removal case doesn't have anything to do with whether the case in state court is going forward or not. Do you see what I'm saying?
It
King, Ship,
it
anybody?
it's confusing.
It's very confusing. Yeah. So, but the government's argument basically is, let's see if I can say it another way. The district court didn't rule that he wouldn't stay Merchand's case. He ruled that you didn't have leave to file a second removal petition. So that's the only thing you're appealing is your ability to file a second removal decision. And that doesn't have anything to do with whether the state court case goes forward or not. And I'm not saying I agree with this, but that's their argument is that it's a disconnect.
No, I understand I understand the point you're making, and I think I understand the point the judge is making is that regardless of your appeal outcome, that outcome does not block the state sentencing.
Right. Now, it's not a judge saying that, Ship. This is what's in the government's pleading.
Okay.
So we're trying to
So so
evaluate their
so the
argument.
remedy
Yeah.
that you're seeking does not operate to stop the state hearing.
Exactly. That's what they're arguing. You got that now, King?
Yeah, I got that, and I'm not sure how
What do we think of it now that we all understand their stupid argument?
I'm, I'm
What do
not
we
sure
think
how
of
the
it?
law is otherwise. I don't know. Even if the motion were granted, the federal court would not stay the lower court, except on an immunity issue. But I'm not sure this is the type of an immunity issue that they can stay.
Well, Trump's lawyers seem to be saying they should be able to do the removal, which would stop the state court case, right? And since they want basically the chance to do that, they want the Court of Appeals to tell the district court, you should have let us remove the case, which would stop the state court case. It would switch it into federal court, right? So they're kind of assuming that they would have won the removal action and gotten the state court case stopped. And so they want the state court case stopped to give them the shot at making that. That seems to be the point.
That's their argument, but it's a slender reed because they
Right. That's why the government's saying it doesn't
yeah,
follow.
and
Right.
and and and,
Yeah.
and I go back to the basic idea of second removal. That almost never happens.
Right.
I mean, they have to have extraordinary circumstances to and show the district court that circumstances have totally changed. And I think the federal district court, uh, wrote a short opinion explaining why it's it really hasn't. It
Right. He said they didn't show good cause why they should be able to file an untimely removal action. Okay. And you can appeal that, right? But in the meantime, they're trying to get Marchand's case stopped. Now, they did that before Marchand had issued his order saying, I'm not doing any of this until November anyway.
so that so I
He,
think that's a signal Marchand gave the Second Circuit, the federal Second Circuit, a signal that there's no reason for you to jump in here.
right. It's kind of
Yeah,
moot at this
yeah.
point. Right. And nobody in the Second Circuit has ruled on anything. They're they're just waiting. So I suspect that the request for the stay in that court is just going to peter out and go nowhere because Marchand's not going forward anyway until after the election. And then, as we've just discussed, he's almost certainly going to get taken up on appeal before he sentences Trump anyway, if it even ever gets that far. And so that is all going to die a slow death. So I think that the removal in New York might just end up being a big nothing. Um, okay, so then let's turn very just quickly to the Georgia case. So, King, do you know what the latest and greatest is? Not on Meadows's Supreme Court thing, because I want to talk about that. But do you know remember what the dates are? Can you remind us roughly anyway what the dates are for the court in Georgia to decide whether Fannie Willis should be kicked off or not?
Uh, Vaguely,
I had a
it
feeling it was this
it,
fall, right?
it's after the election, I think. Maybe briefs. No, I don't remember. I do not remember the dates.
That seems the way it seemed to me, though, too. Like briefs were maybe due before the election, but it wasn't going to get argued until
Yeah,
after.
that's my memory.
Okay. So that's where that stands. But meanwhile, Meadows has filed his cert petition to be heard on his removal action in the Supreme Court. And where that stands is as follows. So Meadows asked, his brief was initially due May 28th, and he asked for and got two extensions to file his brief from Justice Thomas. So Meadows's brief was due to be filed on July 27th, and he in fact filed his petition for certiorari on the 26th. The government then, which now this is the state of Georgia, right, defending this, they asked for their opposition date to be extended to September 30th. So we haven't got to the 30th yet. So they're not going to even file in the Supreme Court their opposition to the cert petition until the end of the month. And then Meadows will have the right to file a reply in October. Um, and then we'll just wait to see is the Supreme going to grant the petition on that or not. But that should be coming, by the end of the year, first part of next year. We'll at least know, are they going to take that case up or not? So I thought, you guys, once all the pleadings come in on that case, we might do a space on that and talk that
There's
over.
an
But
interesting side note to that. Jeff Clark is a defendant in the Georgia case. He also removed to federal court, was denied. He appealed to the 11th Circuit, and and he asked for an en banc, the entire circuit, to consider his appeal of the denial of his right to remove uh, on the grounds of federal the separation of, federalism principles and immunity. Uh, Basically, the conduct he's accused of committing a Georgia crime for uh, has been held by the U.S. Supreme Court to be totally immune as far as President Trump was concerned in his dealings with Jeff Clark. So Clark got a pretty good immunity argument.
yeah,
That's kind of the other side of the coin uh, that Trump used to have immunity held, and that all of that was dropped by Smith from his superseding indictment. But um, Clark's appeal in the 11th Circuit is still pending and has not even been set. It's been fully briefed for months and months and not set for oral argument.
right,
I guess they're waiting to see what Supreme Court does with the Meadows case.
right. I agree. All right. So I'm looking for. Bill has sent me a text here about Marchand's. Let's see. On these dates. So I'm still looking for this.
I found it. I
There we
found it in a
go.
PBS article. He did set that date as September 16th in back in August.
Right. I was pretty sure that it was the 6th, though, based on the actual
Uh,
order. Do you have the actual order in front of you?
I don't, but Andy McCarthy wrote two columns on the point
Mm-hmm.
being 48 hours was meant to short circuit.
Or was the turnaround? Yeah. So maybe I'm wrong about that. I had for sure had it that it was the 6th. I'll see if I can find the actual order. So the the removal, stuff is rolling along. Clark is hopefully going to get heard. Meadows will hopefully be heard, and we'll see what the Supremes are going to make of that argument. Now there is that wrinkle that the 11th Circuit ruled against those guys on this reading of that statute, that it doesn't apply to former officers of the federal government, but only current ones, which I think is crazy. But it's based on a very specific language problem in the statute. So it'll be interesting to see if the Supremes go for that or not. Meanwhile, in the Florida case, did you read, Chip, that I saw your tweet on this? Did you read that brief that Parloff was talking about? It was an amicus brief, a bunch of folks, fools, I would say, filed in the 11th Circuit. This is about Trump's Florida case where Judge Cannon has dismissed it, saying that Jack Smith is not properly appointed.
Yeah,
And the government has appealed that.
yeah,
Yeah.
he's
Let me roll out
good, good.
the dates first. Sorry, Ship. So the government docketed that appeal on July 18th, and their brief was due August 27th. They filed the day before on the 26th. And so Trump's folks have 30 days from the 26th to file, 31 days in August. That means it's going to be due, what, the 25th of September? And then the reply brief will be due 21 days after that, so mid-October. So that case should be fully briefed in the 11th Circuit before the election, but I doubt the circuit will hear it before then. So go ahead, Chip.
Yeah, Parloff he had noted 2 amicus briefs that have been filed, and I'd only skimmed the second one. I didn't even look at the first one. But I mean, Parloff has covered a lot of the January 6th case. I saw him in the courthouse when I was there last week. He was one of the reporters covering the January 6th cases who simply closes his computer once the direct examination is over. He reports the government's evidence and nothing else. So I've always kind of slapping him on the nose with a newspaper. And so I just the point I made he's one of these lefty legal beagles who regularly champions all the briefing from the other side that, oh, by the way, the other side keeps losing.
Right.
So
Yeah. All right. So, all right. Okay. You guys are wrong and I'm right. I'm looking at Judge Merchand's order. I will link it to this spaces. It says the July 11th, 2024 sentencing date is vacated. Okay. This order is dated July 2nd. And there was at that time, the sentencing was set for the 11th. And this order says the July 11th, 2024 sentencing date is therefore vacated. The court's decision will be rendered off calendar on September 6th, 2024, and the matter is adjourned to September 18th, 2024 at 10 a.m. for the imposition of sentencing if such is still necessary, comma, or other proceedings.
read that first part again.
So the earlier part of the order says talking about Trump's immunity motion, right?
But
Okay.
what's the date? What's
Because
the date of this order?
July
He
2nd.
hadn't even filed the immunity motion yet. The immunity decision came down on July 1st.
Right. And the next day.
But there's no motion pending, so he couldn't have been setting a date for ruling on the immunity motion. There was no motion pending. That September 6th.
They already had it. Yeah, but they already had a motion pending saying
but
that.
But then, no, they came along later and filed a motion to set aside the verdicts. That was like.
Yeah, they did.
Wait.
They did.
He set the September 16th date in August.
So he must have changed it again
after they filed the motion for a new trial or to set aside, a typical post-trial motion for a new trial or set aside verdicts, which was late, but they based it on the Supreme Court's ruling, and that was in August.
Okay, so he issued another order after this one, which is why we're kind of both right. So all right.
Exactly.
Let's see if I can
there
find.
Were 2 of them.
So then, if he set it for the
earlier,
16th and was going to sentence on the 18th, then. But what's interesting is that he did issue his ruling that I'm not going to decide on the day that he said initially he was going to, on the 6th.
Yeah, here's a PBS article on the 14th of August, so it's in August, and it says, if I can find the language, It says earlier this month, meaning August, Merchan set September 16th to rule on the immunity claim and September 18th for imposition of sentence or other proceedings as appropriate. So then Andy McCarthy jumped on that and said he's trying to
Not
engineer
enough
a
time.
sentencing that does
Yeah.
not allow enough time between denying the immunity ruling and imposing sentencing for there to be an appeal. But I think he has gotten grief over that because it was pretty transparent that when you only give 48 hours, you did that for a reason.
Right. Right. Okay. So he initially said the 6th, and then he moved it to the
Right.
16th, which he didn't need to do because he still could have kept that 6th
Right.
date.
But that would
And
have
then,
given 2 weeks to appeal.
right, for Trump to appeal. So he didn't do that, but then he ended up issuing something on the 6th
Right.
anyway, saying, I'm not going to do this until November
Right.
12th.
And now and
So
now
I
and
agree with
now
you.
and now he's
Somebody's educating him behind the
right.
scenes.
And now he's built in two
Yeah.
weeks. So
Right, which he had originally, which would be fair, but okay. Plus, if you thought you were going to need the second date, the sentencing, which even in this order from July, he contemplates that maybe there wouldn't be a sentencing, you'd still need time to prepare in light of whatever the judge just ruled, right? 2 days probably wouldn't be enough time in this kind of case. So, all right. Well, I think your overall point is correct, Ship, that somebody is educating him behind the scenes, Judge Merchan, as to like, no, this is really a huge, big ass problem that you've let anything into the trial that was immune. Because if you did,
and particularly when they did two things. They tried the Trump defense tried to keep it out procedurally. They filed the motion
right,
to keep it out,
right,
and then I think at some point there was suggestion that Judge, the Supreme Court just held an oral argument where they said that there likely is going to be some immunity, and maybe we should wait and start this trial after we get that opinion. And he said no.
and he didn't want to do that, and he didn't want to rule on it pre-trial. He said he'd rule on it as the evidence came in, and then the Supremes came along and said it has to be decided pre-trial.
Right. So, he had a litany of bad decision making that was going to be visited upon him. And I also, I just like I texted you, I don't think it was a mystery that, in the last 2 weeks, 3 weeks, the polling tended to show a uptick in Trump's chances. And maybe he didn't want to be the guy who sentenced the next president to jail time after all.
Right. So let's talk about that for a second. So Merchan's order, moving it, his discussion in the order, moving it, all of this stuff to November. He says basically he's doing that in light of the election. He doesn't want to be um, doing something that will influence people's votes one way or the other, and that's the opposite of what Judge Chutkan is talking about when she's trying to figure out what to do in her
Right.
case. So let's debate that. Which of them has it right?
Well, he's in a position of having his cake and eating it too because he's got the verdicts. So to the extent that the verdicts have political utility, they exist regardless of when the sentencing takes place. Now, would the Harris campaign like to be able to also say that Trump is not only a convicted felon but he's also been sentenced? Of course. Well, is there ever is there ever a chance in hell that Trump would actually go to jail before the election? No, that was never going to happen.
No. Right.
That he's going to appeal and he's going to remain out of custody on his appeal. So essentially they wanted the Democratic establishment, Harris Biden machine wanted a 10. Well, they got a 7. They got the convictions.
Yeah.
And basically Marchand saying, like, I'm not going to put my thumb on the scale all the way to give you the 10 you want.
Right.
Win the election, and then we'll deal with it. If you lose the election, I'm not going to be the guy that sentenced the next president to jail.
Right. Right. I mean, he's kind of just kicked that can down the road because win or lose, he's still going to be faced with some problems trying to sentence Trump on the
Oh,
November
I think
18th, don't we?
if Trump wins, I think he'll just vacate the sentencing altogether, let Trump be inaugurated, and then say, "Oh, now he's a sitting president. I can't do anything." Yeah, well,
I can't do anything about that.
we'll
Right.
set a sentencing for January 2029.
January 21st of
Yeah.
2029. Great. Well, fabulous. We'll be doing a spaces that day on that. Okay, but as between the two judges, setting aside the cynicism and the politics and whatever, just looking at what they're saying, Marchand has it right, right? The judge should take into account the election.
Judge
What?
Chutkan not only should take into account the election for democracy's sake, I'll say it, but for Trump's Sixth Amendment right, because it's an election. He's a candidate. Everything he does is in the papers. So when Smith files his magna opus with all of the bad stuff in the grand jury that the grand jury heard that Trump did, that's going to be front page news all over the country. And how many jurors are not going to see that? So,
Right.
Chuck and is, I don't know where her mind is.
Well, I think we're all in agreement on this, aren't we? That she has TDS. Because people want to complain about Judge Cannon is in Trump's pocket, but the judge in these cases who's exhibiting the most partisan, uh, and whether she knows it or not, consciously, I'm not sure, but political behavior is not Cannon, it's Chutkin.
Well, I mean, obviously, I have to be careful what I say in this particular circumstance, but
Yeah, well, you,
there is,
you don't have to comment,
there is
Ship.
a
Just so people
right.
know, Ship is representing folks in front of that court. Judge Chutkin is a member of that court. So if you want to defer
Yeah,
on that,
I
Kim
don't. Well,
can
I
jump
don't
in
have
and
any
spit.
cases in front of her now, but it is a matter of public record, and it's documented that she has made relatively harsh comments relative, as compared to her colleagues about January 6th and defendants involved in January 6th, and has made references to Trump with regard to the events of the day. Um, and I think allowing Smith to try to drive the case to trial 7 months after indictment, to have a case, have the case tried in March, you know, that was an
Right.
obvious
That was
indicator,
absurd.
right? Which, I have
Yeah.
now, I couldn't account for March on, but I have championed from day one that none of these cases would get to trial before the election. And but for
Right.
March on, I would have been right. And just can't,
Right. Exactly.
you can't account for a
Right.
judge who's willing to basically do anything. Um,
Right.
that was an absurd date from the moment she said it. And
Right.
it was only, you know, 75 days later than he wanted to set it, which, just,
Right.
given the nature of the case, just, ridiculous. Um, and now, there is no reason in the case for this September 26th filing, because
Right.
everybody acknowledges, even she said from the bench, no matter what she decides, it's going back up on appeal. And
Right.
it's going to be stuck again in the appellate process for months. She knows that. So, what is the purpose of having this 3-week disclosure? It
Right. Right. Nothing would be harmed from the point of view of, you know, the public's view of the court, certainly, if she didn't say, you guys need to work on this for a while. Let's take up the other more technical things and we'll brief this issue after the
right,
election.
and I think what is missed by the attitude given is the very real, the sort of lack of an acknowledgement that the role the judiciary plays in a criminal case is as a branch of government, and this is, in my view, a separation of powers problem. The role she is
Right.
playing as a member of the judiciary is going to influence the selection of the next executive. And she can't
Right. And
simply,
her saying that that's not so doesn't make it so.
doesn't make it not so. It doesn't matter the
Right.
purity of her decision making, it's the effect of her decision making. The effect of her decision making is to influence another branch of government in a manner that interferes with the separation of powers. She should not do anything that influences who is picked as the next executive because she's a member of the judiciary. You know,
Right. Which was Marchand's point to his
right.
credit.
And the same way that the Speaker of the House should not have a resolution in advance of the election that says the House votes that the country should vote for candidate X.
Right.
What's the difference?
Right. What's the difference? Right. Exactly. King, you want to weigh in on that? Which judge you think has the right and why in terms of taking the election into
No, I
account?
agree. Mershon's it finally has got it right. Judge Chuck, and I do not understand, even if you put separation of powers aside and just look at your jury, your ju- the
Yes. Right. If she looks at case
eh,
considerations, is your point. Forget about the
forget about
election.
the
Yeah.
election. For any defendant in this position with this kind of notoriety involved, you've got to go out of your way to protect the defendant's right to a fair and impartial jury. And she's doing exactly the opposite.
The opposite of that. Right.
You know, it,
So that brings me back to canon
I'll tell you
again.
what. On that issue, if nothing else, if anything positive comes out of this, it might force the D.C. Circuit to re-examine Haldeman.
Okay. So explain that
Okay.
to
So,
people.
all right, we've talked about it before, but who knows who's heard it before?
You can't
United
just
States
throw it
versus
out
yeah,
there at the end.
United States versus Haldeman is a decision of the D.C. Circuit from 1974, I think, involving H.R. Haldeman, Richard Nixon's chief of staff, who was convicted in connection with the Watergate burglary. And Haldeman had made a motion for change of venue to get out of D.C. because that was even the era of three networks and PBS and the New York Times and Washington Post. Haldeman argued that there was such saturation of media coverage in the District of Columbia, he could not get a fair trial. That they could not find a jury of his peers that could give him a fair trial because of unfairly prejudicial pretrial publicity. The DC Circuit issues an opinion that says, the politics of jurors are not typically something that the courts will take notice of, and it is incumbent upon the district judge to engage in a sufficiently probing voir dire, meaning questioning, of prospective jurors to weed out any jurors that might have a bias that makes them unsuitable to sit on a particular case. And that there's no reason to expect that the district judge in the Haldeman case could not do that. Regardless of the nature of the juror pool, you simply keep going through candidates until you find 12. And so, what the import of that decision from 74 was the district judge has to try to pick a jury and fail before the district judge can send the case to another district for trial. Does you get a change of venue
And
motion?
newsflash, they never fail to pick
Eh,
a jury because they browbeat the
Right.
jury.
They basically just they keep questioning jurors until they get them to say, "Well, can you set your opinions aside and decide the case only based upon the evidence presented in court and the instructions I give you?" Once they get a juror to magically say, "Yes, I can," it's like, there you go, through the door, you're on the jury. And if
Right.
you go through a
Yeah.
few hundred people, you can find 12 who can say that, whether it's true or not. Just having them, voice the magic words is all it takes.
Right.
So all of these January 6 cases, the reality is you got a prospective juror pool that, to the extent they're voters, they voted 92% against Donald Trump having a second term. And oh, by the way, now they're candidates for juror candidates to be on a jury of defendants who were protesting wanting Donald Trump to have a second term. So Yeah, no problem there. They can be fair, I'm sure. Just ask them. Um,
Just ask them. Right.
so so and the
Yeah.
and I have raised this issue, not in DC. I raised it in Hawaii. I said, the reality is jurors that want to be on the jury know how to answer your questions.
Right.
The answers are self-evident. If you want to get disqualified and go back to your life, you give answer A. If you want to be on the jury so you can send these insurrectionists to federal prison, the correct answer is B. And
Right.
it is not a mystery.
That's clear to
Right.
everyone. Exactly. Yeah.
So
So that brings me then to canon, because we're going to try to wrap up here now, which is on this question of, is the way the case is being handled procedurally off? And in Chutkin's case, we all agree, yes, it is. But this brief that Parloff was talking about in the 11th Circuit is from a group of amici who not only do they want the 11th Circuit to say that Smith is properly appointed, they want the 11th Circuit to kick Eileen Cannon off that case. And they argue that the circuit has power to do that, which I agree. The circuit does have power to reassign a case to a different judge. But the reason that they give is they say she's rendered insupportable decisions that are outside the reasonable judicial decision making and inexplicably has handled the case from a procedural point of view. So, so these idiots are arguing, well, she's taking positions that we think are beyond the pale, and she's slow rolled that case, so you guys should kick her off.
well they
King, go ahead.
they cite, and I looked at this just yesterday when I was with them. They cite, controlling Supreme Court authority, that her decision is contrary to controlling Supreme Court authority, meaning the Supreme Court has previously addressed this issue of the status of someone in Jack Smith's position and said that it is appropriate. And they cite Morrison versus Forrester, which is an independent counsel case, and I'll get to that in a moment.
Right,
And they cite United
right,
States versus Nixon, which is the Leon Jaworski trying to enforce the subpoena to get the Watergate tapes. And
right,
and so they say that's controlling authority. The independent counsel was created by Congress. So you don't
right.
have the argument with the independent counsel that got Jack Smith kicked off, which is that there's no law authorizing Jack Smith's office.
All right,
The independent counsel was an act of Congress. So
right. Was kind of authorized by the law that's called the Independent Counsel
yeah,
Statute. Yeah,
so that's not controlling Supreme Court authority. And then U.S. versus Nixon, it wasn't an issue. Nixon appointed Jaworski in effect because the regular is a different DOJ regulation, not the one not the Reno regulation that's in effect now, but is a different DOJ regulation. It it authorized the appointment of a special counsel such as Jaworski. Nixon, as president, is responsible for all executive branch regulations. Nixon never moved to invalidate the regulation. So the Supreme Court said, Nixon, you can't oppose Jaworski on the fact that he's not properly appointed because it's in your authority to invalidate the regulation, remove him, but you won't do it because of the political hit you would
because of
take.
political. You wouldn't exercise your power, so why should we do it for
Exactly.
you?
So it was never addressed in Nixon. And in fact, um, in one of the better parts of Cannon's opinion, she goes through in exacting detail why United States versus Nixon does not control the outcome. And she went through and explained that she read every brief that was submitted in Nixon. She read the opinion in Nixon, and nowhere is the authority of Leon Jaworski even addressed.
Right. Right. All the stuff they're accusing her of doing, her opinion addresses
Right.
already. She explained, she looked at stuff that, boy, I would have had trouble dredging up, right? About every special counsel appointed back to, good grief, back to what, the time of the Teapot Dome
Right.
scandals? I mean, that's insane. So yeah, their whole argument that, oh, she should be thrown off because she's making decisions that are against the law and she's slow rolling that case is just objectively
And you know what I'd
false.
like them to answer to? It's like she's slow rolling the case. There are
Hmm.
some January 6th defendants who were charged in January 2021 who have not yet gotten to trial yet. And
Right.
their cases do not involve classified documents being held in the home of a former president.
Right. And complex legal issues that the president's cases all
Right.
involve.
But
Oh, yeah. So it's just like they say it, therefore that's the answer. We're back to King's thing about, you saying these are the facts doesn't make them the facts.
it I looked at that
Go ahead.
and uh, kind of scratched my head. What? Why did they do this? Um,
Right.
I assume they believe in Smith's cause, and they want him to be reconstituted special counsel in Florida to pursue that case. So that was the first part of the brief, how she got that wrong, and he really was lawfully appointed, and that's a reasonable argument. That's not facetious. It's not totally specious. It's a reasonable argument, and as you said, Judge Cannon went through. I mean, they didn't make any new arguments. They made the same arguments Smith had made, and
Right.
Judge Cannon had gone
Right.
through every one of those arguments point by point and explained why she thought they were wrong. She also explained that she thought it was a novel question that deserved a decision, and she went to a lot of work to make a decision. And right there, that's what judges are supposed to do. But the second part of the brief, with which said, "Oh, by the way, you should kick Judge Cannon off this case because she's clearly unqualified and biased." That uh, I learned early on as a lawyer. If you're going to go after a judge like that, you better be damn right, solid, rock solid, and have all of the ammunition, and they have none of it. It's
Like they're drinking their own
they,
bathwater thinking that they have it, but you got
they got
nothing
nothing,
in your
and
hand.
when you do that, when you attach that to the first part, uh, most of the judges on that circuit are going to throw it in the trash.
Right.
They, they defeat
Right.
their cause when they do something like that.
Yeah.
It's like we're in Alice in Wonderland world. Everything is backwards. Cannon is the one that's doing a good job. I don't always agree with her, but she's doing a good job handling that case and making rulings. And Chutkin is an abomination the way she's handling that case. But according to these lawyers on this amicus brief, the opposite situation is what prevails. And I mean, it's astonishing to me as a working lawyer, now retired, that other lawyers can see things so differently from objective reality. It's so
It
dismaying.
irritates me that you keep saying that.
They're saying what?
Now retired.
You're just jealous, my friend.
Well, absolutely I am.
Well, marry a rich lawyer, and that's the end of your that's the end of all your problems. Well, so I don't think there's any real possibility of them kicking Eileen Cannon off that case. Do you, King?
Oh no, no. If they had anybody had any doubt, that brief probably cinched it that she stays on this case.
Right.
If I'm an appellate judge and I got that from on a
Mm-hmm.
amicus brief, I mean
Amicus, yeah.
that brief is going in the trash right then and
Right.
there.
Circular file. Right. Right.
It's
Well,
it's interesting that it's interesting that within the judiciary, and I mean I've known a few judges over the years. Within the judiciary, they hold a view. They hold a view that, as almost exclusively, they try to approach their jobs in a non-political fashion. Doesn't matter,
right.
it's
They
like
do try.
doesn't matter who appointed us. We are all dedicated to trying to get the legal questions correct. We have different views, we have different approaches. Sometimes that produces different results, but we are all trying to do it apolitically. Nothing canon has done has been overtly political.
Right. A deviation from
Right.
that principle,
So
right?
so so all this brief is doing is saying is we don't like the outcomes. And because of
Right.
the outcomes, we want you to infer political decision making. Well, appellate judges don't like to have that said about district court judges any more than they like to have it said about themselves. And like you said, unless you've got it rock solid, that is an argument that is stepping on a rake.
Well, it offends their sensibilities, even if they don't agree with that judge's views or politics, because they see how easily that can be turned against them.
And one of the best examples of this, and they call it collegiality among the judges, right? That's a
Yeah.
term that applies in other instances, but it's routinely used among judges with different political perspectives that they nevertheless have a collegiality and respect for each other. And nowhere has it probably ever been in the modern era more better expressed than what has always been talked about as the very close friendship and respect that Scalia and Ginsburg had for each other, even though they were on diametrically opposite ends of the political spectrum. Scalia would have never stood for, and Ginsburg would have never stood for, um, having the politics of the others said to be the basis for their decision making. They had different views on the law that led to their decision
Right.
making, but it wasn't Democrat versus Republican.
Right. Right. So, all right. Well, a couple of final points here. I'm going to wrap it up. So, one is a couple of our peeps have have said that they would like a ringtone of my laugh, which
Okay.
made me laugh.
Don't give it away for free. Don't give it away for free. You know,
Well,
that's a that's
I
a
was wondering.
that's a lot of acreage you got there to mow,
Yeah, I
to mow
know.
the lawn.
I know. So I'm gonna see if I can figure out how to do such a thing, and if I can, I guess I'll offer my laugh for ringtones. But so stay tuned for that.
You should
But that
you should
also
check
made
with
me go ahead.
check with Kamala Harris's people.
So it also made me think if I can figure out how to do that, we could do some of our other catchphrases, especially some of King's. Like you could do your everything he just said is bullshit from last week, King. And a couple of your other phrases. So I'll see if I can get that worked out. And maybe we'll have some ringtone merch
We're
for
gonna
people.
we're gonna have a merchandise store before long.
Exactly. We can put that on shirts. I don't know. We won't be able to put my
I want
laugh
to.
on shirts,
I think
but
I want a coffee mug with everything he said is bullshit
right,
line.
exactly. We might run into a copyright problem with the my cousin Vinny people. We'll have to look into this. So stay tuned. Maybe we'll have some merch coming up, you guys. Maybe. But the other thing is, we're going to talk tomorrow, and I just wanted to let people know what that's going to be about. Tomorrow, we're not going to talk about any cases per se. What we're going to talk about is the way the government uses the tools that it has to, I'm going to use the word spy. It could be spy, it could be surveil, search, seize, the whole gamut, investigate. The government has, the federal government especially, many tools that it uses. And in many people's opinions, the government is misusing quite
Just
a few of them.
it's just data analysis. That's
Just
all it
data
is.
analysis,
Just
right?
data
Don't
analysis.
worry about it. If you haven't done anything wrong, you got nothing to worry about, right? So anyway, we're going to discuss that. We're going to have a beginning discussion of this tomorrow because I hear many people, I see many people on social media who are right of center, and they are calling out the intelligence tools, right? 702, and backdoor searches, and all this kind of thing that the Patriot Act ushered in a number of these and so forth. But I don't want the right of center to lose sight of the fact that some of the more traditional tools are also extremely problematic, especially in the way that we use them nowadays. And so, the Patriot Act is not the only one in the story, and I it better as a community, we'll be able to make more effective arguments and persuade our elected representatives to do something about these things. Now, I know people often tell me on social media, well, the Congress is feckless, they can't do anything to help us. Well, the judiciary is not going to help us, and the executive agencies are definitely not going to help us. The reality is, like it or not, the legislature is really our only avenue for fixing these problems. So, so anyway, I want to start tomorrow with sort of a look at that, helping people understand what's going on. So, any final words from either of you before we sign off?
That's all I got.
Ship, you need to get some like signature phrases and stuff, so we can
Okay.
we can mark.
Before tomorrow.
No, not before tomorrow. But if
Actually,
you want any
there's
ringtone merch,
a
you got
good
to get some
yeah.
phrases, dude.
So there's a substantial likelihood I won't be on tomorrow. So good luck
Okay.
with that.
All right. Thanks. Well, I mean, I think it's going to be an ongoing conversation. So, you're welcome at any time, my friend, of course. All right. So I think that's enough for tonight. I will say good evening.
Good
Good night, guys.
Good night.